The Payment of Wages Act, 1936, is a cornerstone of India's labor law, ensuring workers are paid fairly and on time. Let's break it down in a Quanda style.
First, is the Act constitutionally valid?
Yes, it aligns with Article 43, supporting a living wage, and does not violate Articles 14 or 19. Courts have upheld its validity.
Second, who does it apply to?
The Act covers employees earning up to rupees 24,000 per month, including contract workers and railway staff. Originally set at rupees 1,600, this limit has been revised to extend protection to more workers.
Third, who pays and when? The employer is responsible. This includes managers, contractors, or anyone appointed. Deadlines are strict. Daily workers must be paid by shift end, weekly workers by week's end, fortnightly workers within 2 days, and monthly workers by the 7th of the next month. Delays can lead to legal consequences and employees can seek redress. Fourth, who enforces the Act? Central and state governments appoint authorities, often labor commissioners, to resolve disputes under Section 15. Fifth, what are the penalties? For employers, fines range from Rs. 1,500 to Rs. 7,500 plus Rs. 750 per day for continued default. Repeat offenses can lead to imprisonment. For workers, fines cannot exceed 3% of wages and must meet fair process. No fines for children under 15. Lastly, is gratuity included? No, gratuity falls under the Payment of Gratuity Act, 1972, but final wages must be paid within 2 working days of termination. In summary, this act safeguards timely, lawful wage payments, balancing worker protection with employer accountability.